to today's NCRMD video, in which we will discuss demon possession and the Charter of Rights and Freedoms. Hello there! Let me be the first to congratulate you on your successful escape from hell, and thank you for consulting with us before you attempt to make demonic possession legal at the federal level. Let's discuss your unique legal position. As I'm sure you've pointed out to the police, there is no actual law or section in the Canadian Criminal Code which prohibits or punishes demonic possession, but actually legalizing it is a different problem. To explain, we'll need to take a look at Section 7 of the Canadian Charter of Rights and Freedoms. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Now remember, the Charter only applies to government and its elected officials, and not to private citizens, so you can't be... You're an elected government official? Harper administration. Okay, so now we have a problem. Let's do the Section 7 Rights and Freedoms test to make sure there's a real issue here. Step 1. Is there a prima facie violation of life, liberty, and/or security of the person? Let's see what engages these rights. For liberty, we have threats to fundamental personal choice crucial to core identity. And for security, there is psychological stress and interference with bodily integrity. Well, it looks like they've got you on both. Yes, preventing someone from making literally any choices amounts to a threat to fundamental personal choice crucial to core identity. No, that would actually not be considered extreme liberalism. It's pretty standard. Well, that's your opinion, but you're a Canadian demon now, so let's move on. Let's now skip to the Oakes test, which asks if the violation is demonstrably justified, and which will tell us if the violation is in accordance with the principles of fundamental justice. What is a principle of fundamental justice? That's a great question, for which I have a lot of examples, but no real definition, because the Supreme Court has never actually defined it. I don't know. Probably so they can make new examples up when they see something they don't like. First, we determine the law's objective. Yes, legalize demonic possession. I heard you the first time. I mean, why do you want to legalize demonic possession? Okay, bring about apocalypse. Yeah, I can definitely see how that is a rationally connected purpose, which satisfies our next step here. Just after that, the court is going to consider whether the law is minimally impairing. Would you say that removing every possible choice from an indeterminate number of citizens infringes the rights as little as would be possible in order to bring about the end of the world? Well, yeah, I suppose. And now the tricky part, balancing the infringed rights against government objective. To override constitutional rights, you have to demonstrate the good which the law may achieve in relation to the seriousness of the infringement. On this count, demonic possession is likely to fail the test for demonstrated justification unless you can convince the court that Canadians would really benefit from being the epicenter of the end times. And we all know that Justice McLaughlin has a heavy anti-apocalypse bias. I'm sorry to disappoint you, but it doesn't look like it is possible to legalize demonic possession in Canada. Do seek further legal counsel, though, because you're about to be put in front of an administrative tribunal for deportation, and it can be hard to tell a judge from a priest at a distance. Maybe avoid the water the especially impatient-looking one is leaving out for you. Thanks for watching this episode of NCRMD. If you have any questions you'd like answered, go ahead and leave them in the comments, and I'll see you next time.